Imagine your deepest connection to a country, your citizenship, suddenly being questioned, or maybe even taken away. It's a powerful, even kind of unsettling idea, right? And for many people, it's actually a very real concern. Today, we're taking a deep dive into the complex world of citizenship revocation. We're focusing on two nations we often compare, Canada and the United States. Our mission is to unpack the legal grounds, the really intricate processes involved, and the profound human implications for individuals caught up in this. And whether you're a natural-born citizen, someone who naturalized later in life, or maybe you're navigating dual nationality, well, understanding how citizenship can be lost reveals some surprising things about what it truly means to belong. We're going to explore some high-profile cases too, and the ethical dilemmas that pop up when the state starts questioning someone's nationality. So let's start at the beginning. Before we talk about losing citizenship, what exactly is it? What defines a citizen in places like the US and Canada?
Yeah, that's a great place to begin because while the details do vary a bit, the core idea in both the US and Canada really centers on two main types. You've got natural-born citizens, those born in the country or, to citizen parents abroad, and then you have naturalized citizens. These are foreign-born individuals who've legally gone through a whole process to get citizenship. And what's really crucial to grasp here is that once you have it, both categories generally enjoy the same fundamental legal rights and privileges.
Like what kind of rights?
Well, you're talking about the right to live and work freely, the right to vote, hold a passport, all those core aspects of belonging to a country.
Okay, so if it's such a fundamental right, how can it ever be lost? I've heard terms like renunciation and revocation thrown around. What's the difference there, and why does that distinction matter so much?
That's a really important question because the terminology here is absolutely key. I mean, it really makes a difference. When we talk about renunciation or sometimes relinquishment, that's a voluntary thing. It's initiated by the citizen. It's when an individual formally makes the choice, their own choice, to give up their citizenship. But denaturalization or revocation, that's completely different. This describes an involuntary process. It's government-initiated termination of citizenship. The state is making the decision, not the individual. For U.S. citizens, for instance, voluntary renunciation usually involves performing one of several specific actions, like swearing an oath of renunciation at a U.S. embassy. But even then, the government still has to prove you genuinely intended to give up your citizenship. It's not automatic.
So it's not just about saying the words.
Not always, no. Intent is key. And it's not a simple process either. Getting that official certificate of loss of nationality, well, it can involve long wait lists and a pretty substantial administrative fee.
How substantial are we talking?
It's been cited at $2,350, sometimes called the world's most expensive fee for this kind of service.
Wow, that's quite a fee just to say goodbye.
It really is. And, what's truly eye-opening is that giving up your passport isn't just a legal step. It can be a significant financial divorce, too. Take the HART Act of 2008 in the U.S., for example. For certain individuals, what they call covered expatriates, it imposes a one-time tax on their worldwide accrued capital gains.
Like you sold everything, even if you didn't.
Almost like that, yeah. Even if you haven't actually sold the assets.
Yeah.
And there can also be an inheritance tax on money left by these former citizens to people still in the U.S.
Huh. So the ties aren't completely severed.
It shows that even when you walk away, the financial hand of the government can still reach out. It's a surprising final tie. And beyond formally renouncing, other actions like, say, naturalizing in a foreign country or taking an oath of allegiance to another country, those can be considered potentially expatriating. But again, the government has to prove you actually intended to give up your U.S. citizenship when you did that.
Okay, so the individual has agency there, making a conscious choice to step away. But what about when the state takes that power away? That's revocation, right? And the grounds for that seem far less straightforward. What specific actions or circumstances can lead a government to actually take away someone's citizenship, both in the U.S. and Canada?
Exactly. And when we connect this to the bigger picture, the grounds for involuntary revocation often revolve around similar core themes in both countries, though the legal specifics and how they're actually applied can certainly differ. A really primary ground in both countries is fraud or misrepresentation.
Lying on the application, basically.
Essentially, yes. In the U.S., your citizenship can be revoked if it was, and this is the legal term, illegally procured by concealment of a material fact or by willful misrepresentation. So think of it like this. The government has to prove not just that you lied, but that you deliberately lied, willfully, and that the lie was material, meaning it was significant enough that it directly impacted their decision to grant you citizenship in the first place.
Okay, so not just any little fib.
Right. And the historical context here is important. This has traditionally been reserved for really egregious cases, like the example often used is Nazis hiding their war crimes to enter the country.
Oh, no.
It highlights how incredibly high the bar has historically been for involuntary revocation. Canada has a similar standard. Their Citizenship Act allows revocation if citizenship was obtained by false representation or fraud, or by knowingly concealing material circumstances.
That makes sense.
Right.
It's about a deliberate, impactful lie.
What about other serious issues like criminal activity?
Absolutely. Serious criminal acts or national security threats are major grounds in both countries. In the U.S., this can include things like terrorism, treason, involvement in groups that advocate overthrowing the U.S. government or activities threatening national security. Also, war crimes and human rights violations fall under this.
In Canada, similar. Very similar, yes. Canada cites serious criminal acts like terrorism, espionage, or treason. They also include participation in organized crime networks and acts that demonstrate serious misconduct or disloyalty to Canada. Then there's the area of foreign military service or dual citizenship violations. The U.S. can consider loss of nationality if you serve in the armed forces of a foreign state. Canada's grounds include serving in the armed forces of a country at war with Canada, but there's a key condition. It only applies if that individual holds dual citizenship.
Ah, so they need another citizenship to fall back on?
In that specific context, yes. They also look at other dual citizenship violations like acts of war or treason against Canada itself. And Canada has a few other specific grounds that are, well, interesting. Things like procedural non-compliance.
Like what? Not showing up for something.
Exactly, like failing to attend your citizenship ceremony or not responding to official requests, or the revocation of permanent residency, which can then have knock-on effects leading to loss of citizenship. And even errors in granting citizenship where the government itself made a mistake during an administrative review.
So the government can take it back even if they made the error.
It can happen, yes. It's also worth noting that in both nations, there are sometimes claims that political motivations can influence these decisions. Those cases tend to attract intense public scrutiny, as you might imagine.
Okay, so we're talking about some very serious accusations. What does this all mean for the actual procedure? How does the government typically pursue these cases in the U.S. and Canada? Because due process is a huge part of this, right? You can't just snap your fingers.
Absolutely not. Due process is critical, and the procedure reflects that, though maybe not always perfectly. In the U.S., denaturalization cases were historically quite rare. For a long stretch, say between 1990 and 2017, they averaged only about 11 per year. Very few. However, that changed significantly under the Trump administration. We saw a really dramatic increase in cases. The Department of Justice even created a dedicated denaturalization section back in February 2020.
A whole section just for this.
Yes, specifically tasked with investigating and litigating revocation cases for terrorists, war criminals, sex offenders, and other fraudsters. The DOJ claimed a 95% win rate in these cases at the time.
Wow, a 95% win rate sounds incredibly high, especially given that heavy burden of proof you mentioned earlier. What does that tell us?
That's an excellent point. It strongly suggests they are likely pursuing cases where the evidence is already pretty overwhelming, ironclad before they even decide to take it to court. Because the government does bear a heavy burden of proof. They need clear, convincing, and unequivocal evidence in these civil cases. That's a very high legal standard.
Higher than preponderance of the evidence.
Oh, yes, significantly higher. And it's even a beyond a reasonable doubt standard in comparable criminal cases. So for them to claim such a high win rate implies they're being extremely selective about which cases they actually bring forward. There was even a memo, a directive from the Trump administration, telling the DOJ Civil Division to prioritize and maximally pursue denaturalization proceedings, especially in cases tied to national security, material misrepresentations, or really any other cases they deemed sufficiently important.
Okay, so a real push there. How does Canada handle the process? Is it similar?
Canada's process is outlined as a structured legal and administrative path that aims for fairness. It starts with an investigation by Immigration, Refugees, and Citizenship Canada, IRCC. If they find grounds, the individual gets a notice of intent to revoke citizenship. This document lays out the reasons why they're considering it. From there, the person usually has about 30 days to respond or request a review by the federal court.
So you get a chance to argue your case.
Yes. If it's contested, IRCC then files what's called a statement of claim with the federal court. This leads to a prosecution where the court evaluates all the evidence presented by both sides. If the court upholds the allegations, the minister then submits a report to the governor and council that's essentially the federal cabinet who makes a final call. It's important to note the Citizenship Act says the minister may revoke citizenship.
May, not must.
Correct. May revoke, even if the grounds like fraud are proven. So there's still an element of discretion there. And the Minister of Public Safety can also get involved, requesting a declaration of inadmissibility on grounds like security, human rights violations, or organized crime as part of this whole process.
This whole process, whether U.S. or Canadian, sounds like an absolute legal gauntlet for anyone involved. Beyond the strict legalities, what are the human impacts? The ethical considerations when someone faces losing their very citizenship.
It's true. It's far more than just a legal battle. It's really where these legal processes slam into fundamental human rights. And the implications are profound, deeply personal. One of the most serious risks, maybe the most serious, is statelessness. If an individual doesn't happen to possess dual citizenship and their only citizenship is revoked,
They belong nowhere.
exactly. Imagine being without the protection of any government, unable to travel freely, vulnerable to human rights abuses, with literally no country to claim you or issue you a passport. It's a truly dire situation. Interestingly, Canada, unlike some other countries, has specifically moved away from policies that could impose statelessness for conduct deemed prejudicial to its interests. That's a significant point of difference sometimes.
That's good to know, but the risk still exists in some contexts.
The risk exists, yes. And critics, like Samira Hafiz from the Immigrant Legal Resource Center in the U.S., warn that overly aggressive denaturalization efforts can inadvertently create a kind of second class of U.S. citizens. Well, the argument is that it leaves those who weren't born in the country, the naturalized citizens, perpetually sort of looking over their shoulder, wondering if their status is truly secure. The U.S. Supreme Court has even expressed doubts about this in the past. In cases like Schneider v. Rusk, they question laws that place a differential denaturalization burden on naturalized versus native-born citizens. They saw it as a potential violation of due process, effectively creating this second-class citizenship.
So the idea is that once you're granted citizenship, you should be fully equal, regardless of how you got there. No asterisks attached.
Precisely. That's the principle at stake. And legal experts like Professor Loubet have also highlighted the serious ripple effects this can have on families, particularly children whose own citizenship was derived through a parent whose naturalization is later revoked.
Oh, wow. I hadn't even thought of that.
Yeah. Suddenly, people who thought they were safely American and had done nothing wrong can suddenly be at risk of losing citizenship themselves. It's devastating. And this brings up fundamental human rights principles, too. The Universal Declaration of Human Rights states everyone has the right to a nationality and that no one should be arbitrarily deprived of it.
Arbitrarily being the key word there.
Exactly. So punitive denaturalization, especially if seen as arbitrary or politically motivated, can certainly infringe upon these international human rights principles. And we can't ignore history here. Denaturalization has been used as a political tool before, like during the McCarthy era in the U.S. More recently, some critics viewed the sweeping guidelines under the Trump administration as potentially fueled by a politically motivated agenda that could, in theory, target a broad spectrum of citizens based on shifting priorities.
Let's bring this to life a bit more with some recent high-profile examples that have really sparked public debate. These cases kind of highlight the complexities you've been describing. First up, Elon Musk.
Right. This is where the legal theory really smacks into very public controversy. Elon Musk, as most people know, born in South Africa, immigrated to Canada, then moved to California. He eventually became a naturalized U.S. citizen back in 2002. And interestingly, at that point, he actually revoked his UK citizenship. Then, in early 2025, after a very public feud between Musk and former President Donald Trump, Steve Bannon went on air and publicly called for Musk's deportation.
Deportation, but he's U.S. citizen.
Exactly. And legal experts were very quick to point out that it would be incredibly difficult, legally speaking, for any administration to just deport Musk. Because he's a naturalized U.S. citizen, it would require that whole legal process of denaturalization we've been talking about. And that process demands solid proof that he lied or committed fraud in their application or during the naturalization process.
An intentional material lie again.
Precisely. The fraud has to be willful and material. Judges are generally very hesitant to strip someone of their citizenship. It's a huge step. So any administration would face a really steep uphill legal battle without that clear, compelling evidence of fraud in his original naturalization.
Okay, so mostly political noise in that case, it sounds like. What about Zoran Mamdani?
Right. Zoran Mamdani. He's a naturalized U.S. citizen born in Uganda. He's a millennial progressive, a New York City mayoral candidate known for strong support of Palestinians and criticism of Israel. After he won his primary election, several Republicans, including Donald Trump and Representative Andy Ogles, publicly called for his denaturalization and deportation.
Based on what?
Well, Trump called Mamdani a 100% communist lunatic. Representative Ogles sent a formal letter to the Attorney General, Pam Bondi at the time, requesting an investigation. The claim was whether Mamdani might have obtained citizenship fraudulently by failing to disclose certain affiliations during his naturalization process. Some Republicans even urged invoking the old Red Scare-era Communist Control Act of 1954.
Wow, the Communist Control Act of 1954. That sounds pretty intense. Is that something that could actually be used today?
It sounds intense, absolutely. But legal sources indicate that no concrete legal proof has ever been presented, showing Mamdani actually violated U.S. naturalization law. And as for the Communist Control Act itself, well, it's very rarely enforced. It's faced repeated constitutional challenges over the decades. And crucially, it has never been successfully used to strip anyone of their citizenship.
Never.
Never. It's widely considered symbolic legislation at this point, effectively unenforceable for denaturalization purposes. So even if, hypothetically, his citizenship were somehow revoked, he'd likely just revert to being a lawful permanent resident. And then a completely separate, different legal process would be required for any potential deportation to even be considered.
So these cases really seem to underscore how high that legal bar for denaturalization actually is, despite whatever political rhetoric might be flying around.
That's a very good summary of it, yes. The rhetoric can be loud, but the legal hurdles are significant.
Okay, so let's say, despite the difficulty, someone's citizenship is revoked after going through this whole process. What's the immediate fallout? What happens next for that individual, practically speaking?
The implications are huge, yeah. Significant and far-reaching. If citizenship is revoked, the individual typically reverts back to whatever immigration status they held previously. Often that's permanent residency, like a green card holder in the U.S.
But what if they didn't have a status before, or it expired?
Right. If they don't have any other legal status to fall back on, they could then face a removal or deportation order from the country. And immediately they lose all those fundamental rights associated with citizenship we talked about earlier. The right to live and work freely without restriction, the right to vote, the right to receive certain federal assistance. Travel becomes incredibly difficult without a national passport. For former U.S. citizens specifically, they're then treated legally as aliens, and they might be deemed inadmissible under certain parts of immigration law if they ever tried to come back.
Inadmissible, like barred from entering.
Potentially, yes. There's something called the Reed Amendment, which aims to block re-entry for individuals who renounce their citizenship specifically to avoid U.S. taxes, though proving that specific intent can be hard unless they admit it. There's also a provision for those who left the U.S. to avoid military service during a war or national emergency.
Does that apply to Vietnam draft evaders?
That's a good question. No, actually, it doesn't apply to most Vietnam War draft evaders because of a presidential pardon issued later, but it does still apply to military deserters from any period. Additionally, for those who explicitly renounced U.S. citizenship by taking that formal oath, there are also some specific federal restrictions, like on purchasing firearms and explosives. And finally, in terms of benefits like Social Security and Medicare, former U.S. citizens are generally treated like other non-citizens, meaning there can be restrictions on receiving benefits while they're residing outside the U.S., unlike U.S. citizens who often can.
Wow. Okay. We have navigated some really intricate legal landscapes today. Citizenship revocation in both Canada and the U.S. We've covered the specific grounds, fraud, national security threats, and others, the detailed, often really challenging processes involved, and those profound human rights considerations. It's definitely clear this isn't a simple, straightforward concept at all.
Exactly. We've seen how both countries approach these difficult situations, sometimes with, similar underlying principles, but sometimes with very distinct legal frameworks. And always, always with incredibly significant life-altering consequences for the individuals involved.
And perhaps what's most striking, at least to me, are those ethical ripples you talked about, especially when political rhetoric gets thrown into the mix, raising questions about statelessness, about fairness, and that whole idea of who gets considered a first-class citizen versus maybe a more precarious status. So here's a final thought for you, our listeners, to maybe chew on. As nations continue to grapple with complex issues of immigration, national security, and political identity, what does this increasing focus, or at least discussion, around citizenship revocation actually mean for the very concept of belonging in modern societies? How might these legal battles and the political debates surrounding them shape who we define as us in the future? And what responsibilities do nations ultimately have to those they once welcomed and granted their highest status?